A trademark is something used to confirm and secure your intellectual property. You make up a delightful cartoon mouse that captains a boat, you trademark it so no one can steal it and build an empire. It's easy. But sometimes those who want a trademark have issues with what exactly constitutes intellectual property and instead try to get a little broad and, dare we say, greedy with what a trademark can cover. Number 10. Disney tried to trademark SEAL Team 6. Let's kick things off with what is going to be a recurring theme behind some entries. At some point in time, a trademark became less a way to secure an idea and more of a way to try and force people to pay you for talking about something in the public eye. On May 3, 2011, the Disney Corporation sought to trademark the term SEAL Team 6. This was in the aftermath of the actual SEAL Team 6 killing of Osama bin Laden, the one-time most wanted man in the world and the terrorist behind the 9/11 attacks. SEAL Team 6 was huge news after what happened, and Disney apparently thought they could make bank on it if they owned the name. Of course, being that SEAL Team 6 was a group of real living human beings and SEAL teams are members of the Navy, and none of them have anything at all to do with Disney, the plan didn't go over very well. Maybe it had something to do with the fact that the trademark request would have also covered things like snow globes and Christmas stockings. Less than 2 weeks later, Disney dropped their trademark request after they were thoroughly roasted in the media. Disney's plan was to create a TV show, sort of like NCIS, about SEALs. The Navy had to make a counter move to protect the name since they actually are the SEALs, and the whole thing made Disney look greedy and opportunistic. Somewhat ironically, CBS developed a show called SEAL Team 6 years later. Number 9. Disney tried to trademark Dia de los Muertos. Let's not let Disney off the hook yet. 2 years after their SEAL Team run, they tried to trademark an entire holiday, filing a claim to make Dia de los Muertos a part of the House of Mouse. Dia de los Muertos is a widely celebrated holiday in Mexico and involves big celebrations meant to honor and remember those who have died. Despite the seemingly somber nature, it's also meant to be a lively and fun time. In 2017, Disney Pixar released the movie Coco, but in the lead up to its release, they had not decided on a title or much beyond the idea that it was going to be about the Day of the Dead. They filed a trademark for the name and were immediately met with a backlash from people accusing them of exploitation and cultural appropriation. Disney's trademark attempt would have covered everything from fruit baskets to jewelry. They even tossed in non-medicated toiletries. The backlash resulted in a widely shared petition and protests. Disney eventually relented, suggesting that they were only looking to trademark the name of their movie and that they had decided to use a different title. Number 8. Harley-Davidson tried to trademark the sound of their bikes. Harley-Davidson arguably makes the most famous motorcycles in the world. They're highly coveted and pretty well iconic in terms of biker culture. And while Harleys do have a distinctive look about them, the company felt that they also produced a distinctive sound. So distinctive, in fact, that they thought it was worthy of trademark protection. For 6 years, the company fought in courts to lay claim to not just the sound, but other design elements, like the teardrop-shaped gas tank, the curve of the fenders, and the general shape of the bikes. Other manufacturers were putting up legal fights, and some of those elements were arguably pretty generic, and the sound of the engine was not the sound of a Harley per se, but the sound of any bike with a V-twin engine. The company finally gave in and dropped their efforts. According to a spokesperson from Harley, the company was tired of spending millions on a case that had no end in sight. 7. A French company tried to trademark the scent of strawberry. Trademarks can be tricky things. A character, a movie name, a song title, these things all make sense as potential trademarks. But what about more esoteric things? Now, we saw an attempt at sounds, but what about tastes or smells? In 2005, a French company tried their hand at trademarking the smell of strawberries. This wasn't born in a vacuum either. A Dutch company had inexplicably managed to trademark the smell of fresh-cut grass, which they used to make tennis balls. As nonsensical as that sentence sounded, it is a fact. Eden Sol tried to trademark strawberry scent for use in soaps and lotions. They were, however, denied on the grounds that one strawberry may smell different from another strawberry, so you can hardly claim strawberry smell as your thing. Number 6. Subway tried to trademark the footlong. Most restaurants that sell submarine sandwiches offer them in 6-inch and 12-inch sizes. The 12-inch subs are often called footlongs because they're a foot long. Not really too hard to figure that one out. But Subway, the biggest of the sandwich chains, decided that they wanted to own the term footlong, and they went so far as to send cease and desist letters to other sandwich chains telling them that they couldn't use the term legally any longer as Subway had laid claim to it. Sending the letters was what you might describe as both bold and underhanded, since Subway had only filed for a trademark trademark, and they by no means legally owned the term. And once the trademark officer went over the application, it was rejected anyway. In fact, Subway kept the whole matter tied up for nearly 7 years, trying to prove that people out and about in the world strongly associated the idea of a footlong sandwich exclusively with their brand. The office disagreed, pointing out that most people think it just describes the size of a sandwich, not the restaurant that makes it. That means they had to remove the TM symbols that they'd added to their menu boards for a term that they'd never really trademarked. Number 5. McDonald's couldn't hold onto an EU trademark on Mc. McDonald's is all about branding, as witnessed by their menu, which contains the McNuggets, McFlurry, McMuffin, McWrap, McChicken, and McEverything else. It's not surprising to learn that the company tried to trademark the Mc prefix in Ireland, and things didn't go over well thanks to Supermax, a different fast food chain. The European Union had to weigh in on who had the right to use the Mc prefix, but Supermax, which has been in Ireland since 1978 and has over 100 locations, managed to hold their own. The case determined McDonald's had not proven any exclusive ownership over Mc, but it also conceded that some items like McNuggets had been so well established that the trademark could be upheld. They just couldn't have carte blanche to use it on every product under the sun. Because they weren't doing anything with it for at least 5 years, which under EU law meant they weren't really serious about using the trademark, it opened the door to Supermax or any Mc restaurants, really. 4. Damon Wayans tried to trademark an offensive term. Comedian Damon Wayans is by no means averse to causing trouble for others when he's motivated to do so. He was famously fired from Saturday Night Live after a very brief run because of a creative disagreement. He went off script and played a background character as flamboyantly and stereotypically gay. Sometime in later life, Wayans made an attempt to trademark a word that we're just not going to say here. To clarify as best as possible, it was the version of the N-word that ends in a soft A. Wayans' attempt to trademark the word was for use in a clothing line in a retail store. The attempt was rejected twice by the trademark office, and though no official reason was given by them, trademark lawyers had no trouble explaining it. There are rules on the books about trademarking terms that are scandalous or offensive to a specific group of people. While many have tried to trademark the word in the past or argue it's not offensive in a certain context, the trademark office doesn't agree. 3. Donald Trump tried to trademark "You're fired." Before he ran the free world, Donald Trump ran a reality TV show boardroom on the show The Apprentice. Each week, a contestant, possibly a celebrity, would be kicked off the show after Trump zinged them with the line, "You're fired." It became a sort of catchphrase, and naturally, Trump tried to trademark it. The plan was to copyright it for using games, but the attempt was rejected for fear that it would be confused with an already existing game called You're Hired. Number 2. Cheerios tried to trademark yellow. Head to any supermarket today and you'll find dozens of different kinds of cereal on the shelves. There's so much cereal, it often has its own aisle in the stores, and one of the most easily recognizable kinds is Cheerios in their iconic bright yellow box. General Mills, the company that makes Cheerios, was so convinced of that iconic status that they filed a trademark claim on their box. Not the name, which they obviously already trademarked, or the design, or the typeface, or any of the other things that would seem reasonable. No, they wanted to trademark yellow, as in the color yellow. Their attempt ended up going to court, where they lost their colorful attempt. In the ruling, it was pointed out that they had literally nothing to stake their claim on, and plenty of other cereals come in yellow boxes. And true enough, there's Corn Pops, Golden Grahams, Honey Bunches of Oats, Sugar Crisp, Cap'n Crunch, and true enough, there are tons of other cereals that come in yellow boxes. The court also pointed out that Cheerios comes in a variety of flavors, and none of the other boxes, like Honey Nut Cheerios, even use yellow, so it's not like they're married to the color. Number 1. A businessman tried to trademark September the 11th, 2001. Sometimes what would have otherwise been an unremarkable and mundane trademark is rendered borderline appalling and offensive as a result of nothing more than timing and circumstance. Such was the case when a businessman named Moti Schneeberg tried to file a trademark for September the 11th, 2001. While much of the world was reeling and in shock from the most brazen terrorist attack in history and the deadliest on American soil, while it was playing out in real time, live on television with the Twin Towers crumbling in flames and people jumping to their deaths in a desperate attempt to escape, Schneeberg realized that he was witnessing something huge and historic and wanted to make money off of it. The trademark application would have covered use of the historical date in various forms of entertainment, including TV dramas, news shows, theater productions, and musical variety news and comedy shows. His claim was that it would be for charitable purposes, and yeah, sure. Of course it was. Schneeberg was one of more than 24 others who tried to file some kind of claim over the date and its events. Most of them wanted to trademark it to use as a slogan so that they could put it on hats and mugs and things like that, because who wouldn't want a fashionable September the 11th hat to wear with the Hindenburg Party t-shirt? The claims were all rejected because you can't trademark a date or anything the public couldn't recognize as a mark.